Good morning, everyone. We're going to get started in another minute, so just give us a minute. It's like waiting for the kettle to boil. Okay, it is 11 o'clock. Thank you all for joining us. Good morning. Hopefully you're staying warm. I know I heard on the news today, I think it's supposed to be minus 34 tonight. Crazy. My name is Leanne Clark. I'm the VP of Wellness and Disability Growth and Innovation here at Cowen Insurance Group. Um, in our Return to Health services, we offer accommodation assessments. And so today we will be talking about accommodations. Over the last, I would say, year or two, we've really seen a spike in accommodation requests. The complexity of accommodation requests has really increased. It used to be years back, these short term, I just need light duties for a short period of time. I've tweaked my back or sit stand workstation to help with the ergonomics. But similar to disability claims, the complexity of accommodation requests has really gone up. So, very happy today to have Pat Forte with us. She is a lawyer and a partner with Miller Thompson LLP. She has practiced her entire career in the Waterloo region, which, Pat, I think, what is that, 5 years?
A few.
Yeah,
I'm
just a few,
newish.
right? Yeah. So very happy to have Pat. And she has many areas of focus, but one of the main areas is human rights, absence management. And so, as an expert on this topic for us today. Before I hand it over to Pat, just a couple of housekeeping items. If you have questions throughout the presentation, please put them in the Q&A. I will be monitoring that. We will have about 15 minutes at the end for Pat to go through some of the questions. She might ask some questions herself throughout, and you're welcome to put answers or use your reaction thumbs up. The chat is open. Again, just for comments, don't put your questions in the chat, please, because I won't be watching for that. Also, if you require captioning, it's available through the Teams event, so I encourage you to use that. And yes, this presentation will be recorded and it will be shared within the next 2 weeks after the presentation. So with that, I'm going to hand it over to you, Pat.
Terrific. Hey, thank you, Leanne, for that introduction. I think I gave you my bio, so I didn't make anything up about me except my years of practice. I was born in a manger many years ago. No, I'm teasing. But hey, welcome everybody. Thanks for taking the time out of your schedules to join us today. The presentation topic is human rights and hybrid offices and a duty to accommodate with a focus on work from home. The presentation itself is, very much geared to the HR employer obligation to accommodate. We'll talk really broadly about the law, premised and grounded in the Ontario Human Rights Code. So this is an Ontario-focused presentation, and followed by, a little bit more of a down the funnel discussion about remote work considerations. We'll discuss a couple of cases about accommodation involving remote work or work from home, followed by, a quick summary, all in 45 minutes. So the first part of the presentation is I wanted to do it this way to make sure we have, we're all on the same level of understanding about the duty to accommodate. But I also appreciate that many of you kind of already have an understanding of what's required. So I'm going to give short service, but some service to that particular topic. So in terms of the law and the source of the employer obligation, there is one main piece of legislation in Ontario, and it's the Human Rights Code. And unlike a lot of other legislation in Ontario or across the board, the Ontario Human Rights Code has this lofty purpose statement set out, before the legislation, the sections begin. Not a lot of legislation has a stated purpose statement, and when the legislation does have a purpose statement, it kind of signals its importance in the grand scheme of things. But this is part of the purpose statement in the Human Rights Code. It's public policy in Ontario to recognize the dignity and worth of every person and to provide equal rights and opportunities without discrimination that's contrary to law. And how this works is the Human Rights Code has paramountcy status. It sits above other legislation. I always like using the analogy of a Lord of the Rings analogy. This legislation, the Human Rights Code, is likened to like the one ring that rules them all. There's other legislation that has to cater to and comply with the employment standards, or excuse me, the Human Rights Code. Government has to comply with the Human Rights Code, and there's one instance that might bring this slide deck to, or this particular slide home for you. There was a case a while ago involving a provision of the Employment Standards Act that was, alleged to have violated a provision of the Human Rights Code, and it was determined that it did. And that's just an easy way to explain the paramountcy of this particular legislation. And importantly, probably goes without saying, you can't contract out of the Human Rights Code. You can't have a side deal with your employees to avoid your obligations. If we pay you this, you'll excuse us if we don't comply with legislation. That's not permitted. That wouldn't be enforceable, and that kind of an agreement would be void. The Human Rights Code itself doesn't just deal with employment law, although our discussion here today is absolutely going to focus on that one singular topic, what an employer's obligations are under the code. But just as an aside, the Human Rights Code does deal with other society areas, services, vocational associations like unions, contract law, accommodation. In this context, it means like housing, hotels, and the like. But again, our focus is going to be on the employment sector and how the code and employers in particular are obliged to comply with the code, specifically in connection with the duty to accommodate. The code deals with many protected grounds, including disability. These are the protected grounds that are listed in the code. I don't have the asterisk. Some of these, but not all of them, these protected grounds are defined under the code. And let me take you to the definition of disability. Now, for some of you who've been doing what you do for a really long time, and you have a disability policy and you're really well versed in the wording of your disability policy, whether it's a short-term or long-term disability plan, kind of set that aside, because the definition of disability under the Human Rights Code is more broadly defined. And actually, as a prop, as I like to do sometimes, in the absence of having my dog here with me, this is my Consolidated Ontario Employment and Labor Statutes and Regulations. What's in here includes the Human Rights Code, and I use this prop just to let you know that the definition of disability, it's fleshed out a little bit in the code, especially the second bullet when it discusses that disability includes any degree of physical disability caused by bodily injury, birth defect, or illness, and it goes on to provide many, many examples. Otherwise, disability in its broad definition includes mental or cognitive impairment, a learning disability or dysfunction, mental disorder, or any kind of an injury, a workplace injury that might be dealt with under the Workplace Safety and Insurance Act. So, digging down a little bit more in terms of a disability, the duty to accommodate is premised around helping an employee with a disability perform the core duties of their job. And there is an onus on the employee to prove that they qualify for that accommodation. So there is a requirement for them to prove they have a disability. I mean, broadly stated, a disability is an involuntary thing. It's beyond the control of an employee, and generally it impairs a person's ability in some measure to carry out some activities of what we consider normal life. And in an employment context, it impairs a person's ability to reliably carry out the essential duties, the functions of their work. And then just as an aside, we're not going to discuss any further substance addictions, but just so you know, drug, alcohol addictions are considered disabilities under the Human Rights Code, and there's a special protocol of accommodation associated with accommodating those types of disabilities, but that's beyond the scope of what we're going to talk about today. Sorry, you're going to see my cursor. I'm advancing the slides on my monitor. Apologize if that's distracting to you. The next two slides are really, really key, and they set up what the employer obligation of accommodation is all about. And it's this. So let's be clear about what the Human Rights Code does. It says you can't discriminate against somebody in employment on the basis of disability because they're disabled. You can't not hire somebody because they're disabled. You can't not, or you can't fire somebody because they're disabled. Then there's Section 17 of the Act that says, basically, I'll read it first. The right to be free from discrimination due to disability is not infringed if the person is incapable of performing or fulfilling the essential duties or requirements of the position because of disability. In other words, it's okay to discriminate against somebody who is disabled when they can't perform the essential duties of the job because of the disability. And the really stupid example I usually relay is, if I have a visual impairment and I go to apply to be a driver for a company, understandably, I might not be able to satisfy the essential duties of that job, and it would be okay for the employer to not hire me in light of my visual inability and my disability. It's a silly example, I know, but wanted to help explain how that worked. But then there's an exception to that. And the exception states, before you find a person incapable of performing the essential duties of their job because of a disability, you have to ensure as an employer that the needs of the employee can't be accommodated without undue hardship. And then there's some considerations about what undue hardship means. So what this means is, before you don't hire somebody or before you fire somebody because they have a disability and can't perform the essential duties of the job, you have to figure out, well, can we help them perform the duties of their job? And it's not at any cost, or it's not, carte blanche. There are some there are some walls or backstops to which employers have to engage in that obligation. And in Ontario, there are only 3 considerations. There might be other considerations in other provinces, but in Ontario, there are only 3: cost, outside sources of funding, and health and safety. I'm going to dig down a little bit more in the next few slides. So really, really quickly, the employer obligation to accommodate legally has 2 parts to it. So if you're in this space, the risk that you face as employers is that you don't do it right and the employee files a complaint to the Human Rights Tribunal. You as employers have to demonstrate that you've engaged properly and reasonably in the duty to accommodate. And you have to know it's very process driven, which is, in a sense, it's easier when it's a process. Unfortunately, it's not necessarily the same process all along, but there are some very general building blocks or steps in every accommodation process that are the same in every case. The solutions are different, the accommodations are different, but the process itself is relatively the same. And you have to keep in mind that there's 2 aspects to the obligation, to the duty: a procedural obligation and a substantive one. and what accommodation looks like is not this, right? It's illegal for employers to just ignore this. It's hard, it's time consuming. It does require a level of understanding, and I would say like expertise, knowledge in this area of law. So you understand what the boundaries are, what the obligations are, what the scope of obligation is, and again, where the boundaries are. Those are really, really important. And of course, partners like Cowen can help in that regard. And this isn't an advertisement. I'm not being paid or anything, but it's important to know what the scope of the accommodation is. Putting your head in the sand because it's hard is not good, and it's illegal in this context. So the procedural duty requires engagement with the employee, having a two-way conversation to discuss. This is really transparent. It's not an adversarial kind of a situation. The employee has a legal obligation themselves throughout this process. They can't just demand, say, I want to work from home, or I need to work from home. Okay, that's a great starting point. But the employee, number one, usually is the one who initiates discussion about the need for accommodation. Employees have an obligation, if it's not readily known to an employer, they need to make their functional needs known when there are restrictions or limitations in their ability to perform core duties of work. Employees have a legal obligation to participate, to cooperate, to answer reasonable questions, and to provide information to you that are relevant to their restrictions and limitations, including they have to prove that they have a disabling condition. You're not allowed to know, what a diagnosis is as an employer. It's private information. The Human Rights Tribunal and the Commission are very clear about that. But what you are allowed to know is about what are the restrictions and limitations that you have, and are they medically supported? The employees have to cooperate with experts to the extent that's needed. That might be a topic in and of itself of a presentation. Can employers get IMEs? The short answer is yes, but it depends. And there are certain instances when you can get an independent medical examination or an assessment. An obligation of an employee is also to meet agreed upon performance standards. And at the end of the day, to perform reliably the essential duties of their job with the employer's help. Now, the employer obligation, there's a lot more obligation on the employer side, but you have to accept an employee's request for accommodation in good faith. You can ask for corroboration, medical corroboration. We need to ensure from a treating doctor that you have these particular restrictions and limitations that require accommodation. Employers have a duty to inquire. So remember in the previous slide where it says it's usually the employee who initiates the request for accommodation? Not always. Sometimes an employee won't do that, but there is a duty to inquire and to initiate the discussion by the employer. Keep that in mind. Your overall, employers have to take an active role. You have to maintain confidentiality. The duty to accommodate is private. You'd involve people on a need-to-know basis within your organization who need to know about the accommodations and be involved in determining what they might be. At the end of the day, one of the things also to keep in mind is your obligation to accommodate involves not catering to a preference of an employee if it's not supported medically by way of a medically sanctioned restriction or limitation. When we talk about work from home, sometimes we assume it's great. Who doesn't want to work from home these days? Don't conflate a preference with an actual accommodation need. You don't have to accommodate a preference, but you do have to accommodate a need. This process is iterative, rinse and repeat. You might go down a rabbit hole in terms of an accommodation that doesn't work out and you don't get to any place. You have to try again and start over in the process. I'm going to give this slide a short life. I'm going to assume that you can all think of examples of what accommodations look like that might work and be reasonable in your workplace. modified work schedule, modified duties, some job restructuring that might remove non-essential duties, but you have no legal obligation to rewrite the whole job description and to remove essential duties and not make the job what it is at its core. A leave of absence is also an accommodation if that's supported. Remote work could be a reasonable accommodation, and the cases that we're going to talk about will explore that. Again, the process that you engage in it revolves around a determination of what can the employer do, what can you implement to alleviate the restrictions and limitations that the employee has by reason of a condition beyond their control, to help them perform reliably the essential duties, the core duties of their job. Ideally, in the context of an absence, when an employee is coming back to work, you would reinstate them to their pre-disability job. You have no obligation to make work for them, though, to create a new job that has no value to the company. A few comments about undue hardship. Again, those three things to consider: cost, health and safety, outside sources of funding. So undue hardship is a very, very high standard, and it requires a lot of careful and rigorous consideration of the three main elements, in Ontario. Some degree of hardship is expected that an employer will need to endure in the accommodation process and in implementing the accommodation. I should mention, by the way, remember that chart that had the two duties, the procedural duty and the substantive duty? The substantive duty is the implementation phase of the determined accommodation. So procedurally, you engage with your employee, with medical advisors to figure out what options are available, what makes sense for the business, what promotes the performance of the essential duties. That's the procedural duty that you're going to document. And the substantive duty is the implementation phase. So in the context of that process, yeah, it's inconvenient. You would rather this not to be happening and to be, putting in these supports for the employee. Undue hardship doesn't include consideration of, well, we have some hardship. It's going to affect employee morale, or if we do it for that person, we're going to have to do it for everybody. It's going to disrupt the workplace. Oh, that's really inconvenient. And I would probably prefer that we didn't do that. Illegal. That's not possible. The only considerations are cost, health and safety, and when you're thinking about an accommodation, is there outside sources of funding? Are there grants available that we can get to help us offset a cost, for example, to implement this requested or this reasonable accommodation? So let's kind of now go further down the funnel and talk more specifically about remote work as an accommodation. And when you're looking at remote work as an accommodation, you have to assess whether the essential duties of the job can be performed remotely in good faith. Key. If the core duties can't be performed remotely, remote work is not an option. I had a case involving my client was an employer whose inventory person wanted accommodation remote work. But as you can probably all gather, the inventory control person required somebody to be at the warehouse to control inventory. There were some aspects of the job that were sedentary and involved working at a computer. Technically, yes, that part could be performed remotely, but the core duties of the job required being on site. And so that remote work request didn't make a lot of sense because the employee couldn't fulfill all of the essential duties of the role because of that. So again, in your framework of assessing remote work, you're not thinking about morale in the workplace. If we have to do it for one, we have to do it for everybody. It's an individualized assessment. That's your legal obligation as an employer. You have to distinguish what are the essential duties. Ignore the non-essential duties. The non-essential duties don't make the job. Think, what are the essential duties that make this job, And can this person perform these duties remotely from home? You're going to consider, are the duties, tied to the physical workplace, like that inventory control job? Is somebody a supervisor? Do they provide in-person service? My receptionist, not mine, but my firm's receptionist, could not work from home, and actually during the pandemic didn't work from home while our office was open because it's an in-person role. Our office services team, though, many of them worked at home, but then anyway, I won't get into that, but you can appreciate the considerations that remote work brings. Consider, can the duties be performed effectively through technology? Does that facilitate the performance of the essential duties? Think about health and safety. Well, are there remote work home environmental risks? Can we monitor those safety obligations? I apologize, I'm gonna just snooze that. Think about operational delivery as well, in terms of the location with which the position is delivering the service. Are there confidentiality or privacy requirements that need to be taken into account? Just going to move a little forward. So remote work might be reasonable if it enables meaningful work, but it's not required when it would fundamentally change the job, and when it doesn't enable the reliable performance of the essential duties of the job, or it creates an undue hardship. We all probably have experienced that remote work requests have become common post 2020. We're going to look at one case where the remote work request happened before 2020. The case law that we're going to talk about focuses on essential duties analysis, the medical corroboration of the need to to work from home, operational feasibility of the employer, and at the end of the day, whether remote work undermines the job's purpose, the essential duties. So let's get into it. And I'm pausing here because I moved my monitors, and to get to this monitor, I have to move my mouse the opposite way. So I just want to, I guess I can't talk and move my mouse at the same time. So the first case I want to talk about, well, both of them are about remote work as human rights accommodations. Both cases deal with how employers have to evaluate accommodation requests that involve working from home, what medical evidence and functional limits must be shown, and whether the remote work would address the disability-related needs. The first case is a 2021 decision of the Ontario Human Rights Tribunal. It involves a teacher with the London District Catholic School Board. I'm not telling tales out of school. This is a reported decision. You can find these kinds of decisions on the public free case database called CANLII, C-A-N-L-I-I, the Canadian Legal Information Institute. And you can put that name into the prompt and you'll find the full case decision. So in this case, the applicant filed a human rights application with the tribunal in 2016. So this is, again, pre-COVID, before work from home became popular. The substantive rights hearing was heard and a decision was released in 2021. There were a lot of procedural battles, I'll say, including one involving the union grievance process. Remember, teachers are unionized, and so the teacher's ability to bring this proceeding outside of the grievance process was tousled around behind the scenes. Something else you need to know about the case, an interesting factoid, was that the case was bifurcated. The hearing proceeded on the issue of liability, and if the Human Rights Tribunal determined that the employer board was liable, then it would render a different decision, and I think there were further submissions about the remedy. So that's what I mean by bifurcated. So the tribunal, well, I won't tell you what happened, actually. The other interesting factoid is that the board waived its right to cross-examined the employee and no witnesses were called. I'm going to ask you, before I go on and tell you what happened, what you think happened. So take these facts with a grain of salt. I think they influence the decision. Okay, so let's get into it. The teacher, the applicant, was a teacher with a disability that caused dizziness, nausea, and light and noise sensitivity, kind of like concussive symptoms. The symptoms were triggered by ordinary aspects in the school environment, and by driving, by busy or open spaces, loud environments, and fluorescent lighting. So in many respects, it made attendance at physical school harmful to her health. And remember in the context that she wasn't cross-examined on this stuff. So this is all fact for the tribunal. Her symptoms sometimes limited her ability to travel. She was effectively limited to short travel, and there were reports that restricted her to around 2 kilometers, and a complete restriction on driving if she was symptomatic. So if she was symptomatic, no driving at all. As a passenger, she could travel no more than 2 kilometers because then she would become symptomatic. So despite the limitations, this applicant demonstrated that she could perform all of her essential duties of teaching from home. Without detriment to her health, because she could control her environment, and of course the driving restriction wasn't an issue. So she requested accommodation from the board that included working from home when she was symptomatic, and other measures to expose various symptom triggers, like being in a quiet workplace and other limited travel. And you have to understand also, her duties could be performed online. E-learning courses were already in place and existed in the board's programming. And so it was in this context that she sought the ability to work from home when her symptoms prevented her from an in-person attendance. And so she presented the request as an accommodation tied to her functional limitations, not just a mere preference. Now, for the board agreed she had a disability, but declined this a permanent remote work arrangement and proposed a bunch of alternatives. So in engaging in the procedural duty, it suggested, go to a school that's closer to you. You don't have to come to this school, or go to another board office that is closer to you, or engage in site-based assignments so you don't, it could restrict your traveling. Now, admittedly, some of those options were outside her travel range. The board was also really flexible with her condition. The board preferred to characterize her request to work from home as a sick day instead, and really expanded her sick day opportunities. They invited her and encouraged her to apply for a long-term disability, which they would support, but she refused because she said, I'm not disabled. I can actually work if I can work from home. The board felt she wasn't cooperating because she was pushing her preferred accommodation to work from home. The board took the position that she was refusing suitable work and suitable alternatives, and it felt that it didn't have to accommodate a preference to work from home. So in the end, the board refused her request to work from home, notwithstanding that she could perform the duties of her work from home. She filed an application with the tribunal. What happened? How many people think, you can give me a, I don't know, use your emojis, thumbs up, I don't even know if I can see these things, that she was successful? The board was wrong. Oh gosh, I can see these thumbs up. Oh, that's so cool. I think everybody can see them, right? Okay, cool. Okay, you're gonna have 3 seconds and stop your response. Okay, stop your responses, because these are all people who think, yeah, she won. Board is wrong. How many of you think, oh, and here we have a chat. Yeah, you can use the chat too. How many of you think, do your thumbs up, because I really like that wave of support. How many of you think that she lost? Okay, so we have a kind of a 50-50 split maybe. It's a little weird for me to be saying thumbs up, somebody's clapping, she lost. There's so much enthusiasm with the thumbs up associated with somebody losing a case. Oh my gosh, what kind of people are you? All right, I'll tell you what happened. So the tribunal found that in these circumstances, the board, as an employer, had a clear duty to accommodate by permitting remote work, unless undue hardship could be shown, and the board showed no undue hardship. It wasn't on the board's radar. It just said the board's position in this case was, hey, we fulfilled our duty to accommodate. Undue hardship is not even on the radar. She's the one who's not cooperating. She failed in her legal obligation as an employee to engage in the duty to accommodate. She's after a preferred accommodation. We've offered so many. We fulfilled our duty. So I don't believe that the board really ever seriously considered that it would be stung on the issue of undue hardship. So the tribunal determined that the board had discriminated against her on the basis of disability because remote work was a reasonable and effective way to accommodate her limitations. The tribunal accepted the medical and functional evidence. She wasn't cross-examined on this stuff. Of course, the tribunal accepted this stuff. Anyway, rightly or wrongly, that was the evidence, and it showed the employee's disability caused specific restrictions, including with travel. So that was all legit. This person can't travel, and she also had other, the other sensory deficits or sensitivities. That established the protected ground, disability, and the nexus to work performance and attendance. So because the board knew, or ought to reasonably have known, about the disability and its effects, the board had a duty to engage in a meaningful, individualized accommodation process to provide reasonable accommodation short of undue hardship. And it was the board that didn't engage in that process satisfactorily. So the tribunal determined that remote work was a reasonable accommodation in the circumstances. The tribunal found that the e-learning or coursework could effectively be performed remotely, permitting that work to be performed from home, addressed the core functional limitations, especially the short travel. And because remote delivery of some of the duties was already part of the board's program, the tribunal treated remote work as a feasible accommodation. You already allow it. So what's going on in this case of an obligation to address an individualized accommodation plan? It was not an unreasonable operational burden in principle. And importantly, there was no, like the board didn't make out why it was so key that the duties of this teacher's work be performed in person, again, in the context when there was already an established e-learning platform. There were alternatives proposed by the board that the tribunal found were not adequate. The placing the applicant employee at alternate work sites were beyond her travel limit, requiring her to use sick time when symptomatic didn't meet the duty to accommodate. And the tribunal was really critical of the board's, duty and how it carried out its duty. That basically said, be off work instead of requiring us to accommodate you. So I should note parenthetically that in 2024, the tribunal released its remedy decision, and the board was ordered to pay a $10,000 award for the discrimination, and then it had to pay some back wages, lost wages, when this person was taking time off instead of working, and that was about $125,000 lost wage award. All right. Oh, hey, I forgot this slide. You already answered. All right, let's move on quickly to the next case. The next case is a union grievance arbitration case considering Quebec's Charter of Rights and Freedoms. It's a 2025 decision. Now, the decision, when you look at it on Canley is in French. So my understanding of the case is based on the translation of the decision from Google, very prominent translator, Google. I think it did a pretty good job. I got the gist of the case. But in the case, a unionized employee who was a guidance counselor for a school board in Quebec sought a medical accommodation that would allow her to work from home. Sound familiar? Just like the other case. Arguing that her disability prevented her from traveling to the workplace. Sound familiar? It's the exact same case. Is it? The role, whoops. Okay, well let me stay on that screen, and I'm going to just fix my cursor to go to my other screen. I apologize. There we go. So as a guidance counselor, this employee helped students find housing, admissions, counseling, directed students to resources. She provided on-site support to students. She also attended, the decision referred to campuses. I don't know if it was remote school locations or literally like post-secondary campuses in remote locations. But my impression from the case is that the position as a guidance counselor, you can all appreciate or recall what that entailed when you were in high school. In-person contact, travel to other destinations to perform the services of her position. The applicant employee advised students who attended her office about their academics, provided advice and options about post-secondary school, and she was the only one who performed that duty for the board. The employee's disability included walking restrictions of no more than about 400 meters. I think that's once around a high school track, if I'm not mistaken. She could walk about 150 meters in 6 minutes. She would become breathless and would need to rest. She couldn't do stairs. She was unable to complete a trip on public transit. It was revealed during the hearing that she was approved for paratransit. It's a more tailored door-to-door service, but the employee felt that was too demanding because it just took longer to get to work than regular transit. In her favor was the fact that during the COVID pandemic, she actually worked remotely, performing her role by phone, video conference, email. And in 2023, she had been on a leave of absence, and part of her graduated return to work was supported by remote work. So at this stage, in the lead up to this arbitration grievance, the employee had asked to perform her duties remotely because, as she did during the pandemic and her graduated return to leave on a more permanent basis. She wanted remote work on a more permanent basis because of her underlying condition. The union supported her request, kind of pointing to the past, not practice, but what she did during the pandemic. Yeah, she can talk to students by phone or by email or video conference. And whatever needs to be done in person can be done by other board employees. An important fact in the case is that the board territory was really vast, and the board dealt with sparse populations in areas far away from its core center in Montreal. The board refused the accommodation request on the basis of undue hardship. That's different, right, from that other case? The school board in this case leveraged undue hardship. It said that the employee's return from her leave of absence, it couldn't accommodate a remote work on a permanent basis. On-site was an essential requirement of the position. The board expressed that undue hardship was created based on the students it served. They required close supervision. These were kids who were expecting, the tactile experience of a guidance counselor. Somebody needed to address their specific needs. And the board made a big deal about the in-person support and said without in-person support, it violated the students' rights not to have that access, that in-person access of these services that the board was obliged to provide. So in that context, what do you think? What did the arbitrator do in this case? There's a twist. But what do you think? Okay, let me prompt you. How many of you think the board in this case was wrong, didn't meet its standard of undue hardship, and so the employee won? How many of you think the employee won? Do your thumbs up or any other emoji. Okay, I don't know about you, but I don't see any. How many of you think that the board won? I don't see anything.
There's lots of thumbs up, Pat, for the board winning. Not as many for
you know
the
what?
other.
I have my, okay. Well, let me tell you what happened. The arbitrator accepted the board's argument about the importance of work, about it being, in person. It has to be in person. That's a bona fide occupational requirement, and that's justified. The in-person work was a good faith requirement of the role, and it formed a good faith essential duty that was connected to the objectives of the role. And this is language used by the Human Rights Tribunal. It sets the standard of what's required. You can't just arbitrarily say, oh, it's essential. It has to really make sense. It has to be a reasonable argument that, no, this is a core way to manifest the purpose of the role. It requires in-person attendance. Then the arbitrator said, yeah, so we buy into this, that in-person attendance is needed, but you still have a duty to accommodate to the point of undue hardship. The arbitrator reviewed all the potential transportation options. Public transit was unsuitable because of the physical effort required to get from the stop to the stop, etc. Buying a vehicle was too costly and physically demanding. Shared car services were impractical given the distance and parking challenges. Taxis were prohibitively expensive. But then the arbitrator said, adaptive transportation, that paratransit, that is a viable solution. Consistent with the employee's functional limitations. It drops you off door to door. Hey, employee, the first time we're finding out that you were accepted for paratransit is during this hearing. You failed to disclose that you had been approved for paratransit. By withholding this crucial information, you've prevented your union and your employer from properly assessing feasible accommodations. And so the arbitrator concluded that the accommodation process broke down because the employee didn't cooperate with the process. Remember, the little factoid that I gave you was, it was disclosed that she was approved for paratransit, but it increased her commute time. Who cares? That wasn't a viable or a legitimate reason to discount the potential accommodation. So there was no failure by the employer in this case. It was the employee who the arbitrator determined actively withheld the only realistic option that would have enabled a workable accommodation to get her to the workplace. And so her complaint was dismissed on that basis. A lot of you are probably thinking that was a trick case, and you probably are angry at me. Be angry at Leanne Clark, our host.
Thank you.
But hey, let's wrap up. And I know I'm really cutting into our Q&A, so let me do this quickly. Your obligation, when I say you, I mean as an employer, the obligation to accommodate is to accommodate ideally to a pre-disability role, ideally. The key is that the employee has to still reliably perform meaningful work. They have to perform their essential duties. So accommodation just means, what can you do as an employer to help them do their core duties? It doesn't mean, okay, let's get rid of that core duty, let's get rid of that core duty, let's get rid of this core duty, or they can do that little bit. No, that's not what it means at all. What you can do is say, okay, this isn't a core duty. If they can't do it, let's get rid of that because it doesn't shape the job. We can get rid of the wheat from the chaff, but what you're left with is the core duty, and the employee has to be able to meaningful or perform those core duties with or without your help. In office work, if you're maintaining some reluctance in accommodating work from home, you're going to have probably a hard time unless you can rationally connect in office work to the role. Remember, accommodation is a two-way street. Cooperation by both the employer and the employee is key. An employee's preferences are not determinative, especially if they're just preferences. And that's kind of what came out in the second case, right? It was the employee's preference to work from home, and she pushed that accommodation, whereas there was a way to get her to the workplace, but she didn't disclose it. Undue hardship is a litmus test. Don't rely on issues of inconvenience or more. It's going to affect morale in our workplace. Those are not proper considerations. They're illegal considerations. Okay, now I'll go on. Sorry, apologize. There we are. Any questions?
Thank you, Pat. That was awesome. There are many questions. We probably won't get through them all, so we'll take them away if we don't get through your questions. I'm going to start with one that I get often, and that's something like migraines that are considered a disability under human rights. As an employer, are you just expected to accept a doctor's note that says the employee may miss days of work? And I do see this a lot in our practice as well. The employer is asked what they can do to accommodate the employee, and the employee is not willing to discuss it.
Okay, so there's two questions there. May miss days of work. So you might have policies in your workplace that allow people to be sick. A lot of workplaces have those. The Employment Standards Act has some statutory leaves. You can be away sick for 3 days unpaid. Nowadays, there's, as of June 2025 in Ontario, there's a long-term illness leave up to 27 weeks within a 52-week period. It does not have to be taken in a row. That leave is actually applicable to episodic types of conditions. And so for me, one of the flags that came up in that question, Leanne, was, may miss days off. For me, in my head, I'm going, okay, does that constitute the reliable performance of essential duties? But then I have to juxtapose it into what other rights does the employee have? The employee has rights to take some time off, probably under your own policies and under the employment standards legislation. And so those things have to be considered. The second part of the question dealt with, the employee is not really participating in an employer's request for further information. That's illegal. The employee should be reminded that they have an obligation to cooperate in the accommodation process. The employer in that instance has every right to engage the employee in further information. Missed days from work is not how this works. It's how can we help you? How can it to help you do your job so you don't have to miss work? Is it a sensitivity to lighting? Like if you were to come to work, what can we do in the workplace to mitigate your migraine? Do you have to be in a quiet place? Do we have to be in a low lit room? You can have that conversation. You're fully entitled to it, and so you're going to want to share in a very professional way. It's not adversarial, right? Consider or remember that you're creating the documents that are going to be exhibits in potentially your human rights hearing, and so you want to be professional. You want to demonstrate that you understand the employer's obligation, and you're schooling in a nice way the employee to remind them about what their obligation is. And frankly, if the employee doesn't comply, then it starts to question: do you have a duty to accommodate? Right, like in the second case. So I would say that's a loaded fact situation, and I'm not doing it justice. So I would recommend whoever asked that question, get some legal advice to layer and address the nuances of that case.
Right. And ideally with an employment lawyer, I would guess, right?
Oh my gosh, don't go to your corporate lawyer.
Okay.
Yeah, go talk to your employment lawyer. This is a very specialized area of law. So make sure you get that expertise, the right expertise.
Okay, thank you. Next question. The employer has a right to inquire or duty to inquire if they want an IME as part of that and the employee is refusing. What happens next, or what is the right or allowance at that point?
Yeah, so there has to be a reason for an IME. So the Human Rights Commission has published a guidance about accommodation. It's really long. It's available though, and it's probably a good read. It gives you a neat understanding of the duty to accommodate. Um, and in it, it does talk about when can you get an IME. Now, in some instances, if you're in a unionized workplace, you're going to want to check your collective agreement to see if if you have the ability or if there are any restrictions on your right to do that. In the absence of any contractual ability to get an IME, you are allowed to get an IME in certain situations. For example, when there is inconsistent medical information or discrepant medical information, you have doctor's note saying X one time and then shortly thereafter says Y and you don't understand it. It's contradictory. In another instance, it's not reliable information for various reasons. So in that context, you can ask for an IME. And what the IME is, obviously, you wouldn't never find out an employee's diagnosis as an employer. An employer cannot access employee diagnosis because it's irrelevant to the functional restrictions. The only thing you're allowed to know are the functional abilities, restrictions, and limitations that you may need to accommodate. And again, it's only when there are functional restrictions or limitations pertaining to the performance of the core duties. That's what triggers the duty to accommodate. So, in a situation where you are allowed to get an IME, you have to get over that hurdle first. It's not an as of right thing you can do at any time, but assuming you have the right to do it because you meet certain criteria, either contractually or it's permissible under human rights, and your employee refuses, well, that could be an instance where an employee is not cooperating. And a lot of it might involve you communicating these obligations that the employee has, sitting them down, having a two-way conversation, being very transparent about what your employer obligation is, but reminding the employee that it's a two-way street, and maybe presenting them with some, I call it authority, like the basis or the reason of what permits you to get the IME. Again, something that an employment lawyer who works with human rights can help you with too.
Okay, great, thanks. And I know the answer to this one, but I'll let you comment. Is accepting a lower standard of performance considered an accommodation? So do they have to accept that someone is not able to do the job very well?
That's an interesting one. I remember a matter involving a professional engineer where that came up. And when I'm thinking about an engineer drawing plans and stamping them, you in that particular case, lowering performance standards is a concern and potentially even professionally prohibited. All right, but it requires digging down to understand what exactly does lowered performance mean exactly. It shouldn't require the somebody else doing the job or somebody else correcting mistakes that might be made. So I'm always concerned when we talk about lowering performance standards. It also depends on if it's a temporary thing or a permanent kind of thing. It depends on what the employee is doing. Is there a health and safety risk? Like for the engineer that I was mentioning, that's an undue hardship. I would say it's a health and safety issue. So those two factors: permanence of the accommodation request, context of the role. Are they creating a health and safety risk? And what exactly does it mean? And how is it manifesting? Is it because of concentration deficits? Can you accommodate by just providing more training? Can you accommodate by providing more time to enable them to perform the task? So I wouldn't say that the lowered performance is necessarily acceptable, but there's something more to it that you can accommodate. So I don't think that's the real issue, if you know what I mean.
Okay, yes, thanks. Okay, you talked about the London situation where the teacher won in that case. So question is, given that remote online classes have significantly reduced because funding has changed, and you look at that with post-secondary as well, But in high schools, they have a requirement to graduate for 2 online credits, but the classes are often being canceled due to low enrollment in those, or the teacher's not qualified to teach whatever those subjects are that are available online. So what would that look like in that situation?
Yeah, so maybe the easy answer there is the board doesn't have an obligation to make work. So in a scenario where a teacher requires an e-learning course, but there's not sufficient enrollment in the course, there's funding, right? Outside sources of funding. Like there are undue